Welcome to a courtroom case that is bound to leave you speechless. Today, we're following the case of Daryl Bowman, a man whose life sentence is being revisited after a major change in the law. This case is particularly intriguing because it challenges the constitutionality of life sentences without parole for juveniles. What happens when the justice system decides it's time for a change? When a man convicted of a brutal crime decades ago gets a second chance, will the victim's family see justice, or will the law's shifting landscape create more pain? Stay tuned as we break down the drama, the legal twists, and the heartbreaking victim impact.
Reflected defendant is present here in the courtroom today. This is a date and time set for a resentencing pursuant to the change in the law based on case law and a new statutory provision regarding the sentencing of juvenile life sentences without parole. I'm also in receipt of numerous letters from family. I did have a chance to read all of those letters. Can you tell me your name just for the record?
My name is Roger Allen Cronk.
Thank you. What is it that you would like to say today, sir?
Just wanted to show you a few pictures. This is my mom and dad. We had 8 children in our family. Ronnie was a pretty awesome guy. He knew what he was going to do his whole life. You know, he was one of those kids that got all A's in schools, was in all the sports. Everybody loved him. He was coming home that day to give his girl a ring. And he was meeting with the guy that owns a pharmacy up there. The guy that owns the pharmacy up there was helping get him through college. He would have started a family. He would have had the business taken over. He'd be same age as Mr. Bowman. They were both the same age, with just days apart, I think, on birthdays. This was our family picture with my dad and 7 boys. I'm the baby. This was Ronald. This was just before he went into college. Looking at his girl, Mary. All these people just, their life just went to hell because of this man and George Bowman, you know. This was Ronnie with me. He was an awesome fellow. He would.
We begin with an emotional moment, the victim's family sharing the harrowing impact of Daryl Bowman's crime. Imagine having to identify your own child, not by their face, but by a scar on their knee. It's chilling. Ronald Cron was not just a victim. He was a beloved son, brother, and friend with a bright future. His family's grief is unimaginable, and now, decades later, they must face the reality that Bowman might walk free one day. This isn't just a legal case, it's a fight for justice and closure for a family that will never heal fully from this tragic loss.
Stand out in the yard, him and my brother would hang on his arms and he'd twirl us around. This was Ron right before it happened. Ronald was beaten, cut, and stabbed so bad, my father couldn't identify him. My dad said, I don't know if that's my son or not. He was only identified because there were so many boys in our family. My mom put our names in our underwear. That's how it was handled. That's the only way he could identify him. And then he also saw a scar on his knee that he got during football. I don't know if I know the entire truth. 57 years ago, I was 9 years old, but I remember my dad coming home from that day, 2 priests on his arms. When the priest got out of the state police car, I knew something wasn't right. My dad was bawling. Never seen my dad cry, ever. Ever then. That was the first and the last time. You know, I heard my mom scream, and they made all of us boys go outside and sit outside. And we knew that that was Ronnie. That was dead. From what I understand, Mr. Bowman has never taken the responsibility of that. He was there. He said he wasn't there. His mom said he wasn't there. She testified in court saying that he was with her. Long time ago, I put this in God's hands. I said, you know what, Daryl Bowen, I forgive you, but I will never forget you. I can't forget it. You know, I mean, you can just imagine having to identify your child, but you can't identify your child because they're beaten so bad and cut so bad. I never forgot laying in the.
As we hear from the defendant, Bowman acknowledges his actions, blaming alcohol for his poor decisions. But can we really let someone off the hook just because they were drunk? Alcohol doesn't erase the horror of what happened that night. Bowman's attempt to paint himself as a man capable of change doesn't sit well with the family who lost everything. The legal question here: does alcohol diminish responsibility, or does it simply reveal the true nature of a person? The court has to decide. Should the law show mercy, or should it uphold its promise of justice?
Casket. They had to put so much makeup on his neck because his neck was cut so bad. And at 19 years old, you know what? You can pick up a rifle. I did at 17. I picked up a rifle and defended my country. So was it that different 57 years ago? I don't think so. I mean, people were in Vietnam at that time, younger than 19. You knew what you were doing. But in 1987, he was 37 years old. He knew what the hell he was doing then. He helped organize a prison break. Two guys, Daryl and one guy, just, they didn't do anything, of course, but one guy that helped get out, he had murdered a Michigan State trooper. That guy was all over the Midwest. He robbed 5 banks. And in Mississippi, he robbed the wrong bank and came up against the wrong sheriff. That was the end of him. But at 37 years old, Daryl should know what's going on. He should be held responsible for that. He should be responsible for the 5 banks that were robbed if he helped that person get out. From what I understand, he's the one that got the keys. They got up in the air conditioning ducts, called a taxi, got out of there. But he should be responsible for that, 37 years old. Your Honor, you have the right to keep Daryl in until he meets his 60th year in prison. You also have the right to give him 5 more years after that for the escape from Michigan State Prison. All I ask you to do is do what your heart tells you, be professional, and do your best. That's all I want you to do. If Daryl gets out, it's by God's word, and I have no problem with it.
Now, here's where things get complicated. The law has changed, and Bowman's life sentence without parole is no longer automatic. Thanks to a ruling from the Michigan Supreme Court, juveniles are given a second shot at life outside of prison. But what does this mean for victims' families? For them, the sentence was supposed to be final. They thought this man would never walk free. Now, prosecutors are left with little room to argue. Can you imagine the emotional roller coaster for those who were promised finality, only for the law to change the rules on them?
This is the last time I'll speak about it, last time I'll think about it. After this, I'll just destroy everything and we'll be done with it. So, and that's it. Thank you for listening to me. Family appreciates it. I'm the only brother left. I promised my mom and dad I would never stop until it was time. And today is the day. So, thank you, sir.
Your Honor, this case pains me a great deal because I feel like I have no choice but to agree to a term of years sentence. The Michigan Supreme Court, without any individualized consideration, retroactively threw out hundreds of life without parole sentences across the state. Families like Mr. Cronk's have had their peace of mind ripped away from them by this ruling. They were told at the time that it was life without parole. They were going to be in for the rest of their lives.
The prosecutor has a difficult task here, one that's made all the more complicated by the court's ruling. While the defendant has served 56 years, The legal system forces the prosecution to consider the possibility of parole, despite the horrific crime he committed. The prosecutor's frustration is palpable. How do you explain to a grieving family that the murderer of their loved one might not spend his entire life in prison? The law is clear. The system must follow the rules. But does that mean sacrificing justice for a crime so terrible? This case is a reminder that the law doesn't always deliver what's morally right.
And the Michigan Supreme Court has decided that's not the case anymore. And I can't change that Supreme Court decision, Your Honor. Their ruling was a rebuttable presumption exists now that the defendant cannot be sentenced to life without parole, and I can only overcome that presumption by clear and convincing evidence. While a layperson might not truly understand the mountain that creates for the prosecutor to climb, in this case and in other cases across the state, I certainly do, and I'm sure the court certainly does. I cannot agree with the Supreme Court's ruling because it forces me to try and explain to the victim's family something like this murder was not the most egregious murder in the grand scheme of things. How do you tell someone that? How do you tell someone that their brother being beaten to death with a tire iron on the side of the road for $3.55 is not an egregious murder? You just can't, Your Honor. To the victim's family, this is the most egregious, the most despicable, most inhumane thing they could ever envision. But to you and I, Your Honor, and to other attorneys who deal with this stuff on a regular basis, it's probably not the most shocking or gruesome murder we've dealt with, even in the last 8 years, even just in this small rural county in Michigan. And to overcome a presumption by clear and convincing evidence, the crime would have to be exceptionally brutal, would have had to involve multiple victims, or would have had to have been a part of some organized criminal activity or some other significant aggravating factors. And unfortunately, this murder just wasn't those things, Your Honor. The defendant had no criminal history prior to this murder, not even as a juvenile. The defendant has no criminal history after this murder, although it's worth noting, and Mr. Kronk did note, that he escaped from prison in 1987.
Bowman's apology, delivered in the most heartbreaking way possible, feels like a last-ditch effort to gain some sympathy. He admits to taking Ronald's life and expresses remorse, but is it genuine? This isn't just a courtroom plea for mercy, it's an emotional confession. Yet one can't help but wonder, does an apology, even after so many years, undo the damage done? The question remains, should we believe him, or is it too little, too late?
He voluntarily turned himself in a few weeks later. Had he not already been subject to a life without parole sentence, it may have been a prosecution and it may have been a consecutive sentence. But aside from that escape, he's had a grand total of 2 other infractions in prison in 57 years. Those being disobeying a direct order in 1995 and possessing stolen property in 2004. And that's it. And while 3 infractions, again, sounds serious to a layperson, you and I know that most prisoners rack up misconduct tickets at a rate of 2 or 3 a year on average, and some of them significantly more than that. I can't say his conduct before the offense overcomes the presumption. There's nothing there. I can't say his conduct during the offense, as horrible as it was, overcomes the presumption. I can't say his conduct after the offense, although it was not perfect, overcomes the presumption. I cannot in good faith come before this court and tell you that this defendant or that this murder were especially deserving of punishment above and beyond all other murders. We've just sentenced a murder in Kalkaska a month or 2 ago, Your Honor, who I felt was far more deserving of a life without parole sentence in my mind. And that was not even an option on the table for that offender. With all of that said, Your Honor, if a life without parole sentence is not on the table.
Here comes the judge, caught between a rock and a hard place. The law says Bowman should get a maximum sentence of 40 to 60 years, no more, no less. But what does justice look like when the crime is this horrific? The victim's family deserves more, but the law limits the options. The judge's personal feelings about the case are clear, but as a judge, they must adhere to the law, even if it doesn't sit right. It's a sobering reminder of how sometimes, even when a judge feels the weight of the case, they have to abide by the rules, even when it feels like they shouldn't.
Able for this defendant, the next best thing is the maximum term of years that the statute allows. That would be 40 to 60 years. And that is what the defense and I have agreed to, and that is what I asked the court to do today. I hope the court and the family understands. If I thought I had any reasonable argument to overcome the presumption in this case, I would be up here making it. But I can only ask the court today to follow the rules that have been laid out by the Supreme Court and to give this defendant the maximum sentence allowed by those rules. Thank you, Your Honor.
All right, thank you. Counsel, if you and your client can come up to the podium.
Yes, Your Honor. And Mr. Bowen does have a statement he wishes to address the court as well. Your Honor, I would like to start by acknowledging the tragic and senseless loss of life in this case. All of these cases are first-degree murder cases, and there is nothing, all murder is heinous, all murder is egregious, and in these cases, we are focused on the punishment. And both the United States Supreme Court and our state Supreme Court have found that it is cruel or unusual to mandatorily sentence juveniles and adolescents to life without parole. And so I know that I submitted a sentence.
And with that, the decision is made. Bowman will serve 40 to 60 years for the murder of Ronald Cron. It's not the life sentence that the victim's family wanted, but it's the maximum allowed under the new laws. This is a case where the law's change has complicated what seemed like a straightforward punishment. While the victim's family wanted a final sentence that would guarantee no future freedom for Bowman, the law has forced a compromise. What does this mean for other cases like this one? Can we expect more shockwaves in the justice system as families are left in the wake of these retroactive rulings?
Sentencing memo for Your Honor's review, and I won't belabor that now. And as the prosecution pointed out, Mr. Bowman can only be resentenced. Anyone can only be resentenced to life without parole if they are incapable of rehabilitation. And Mr. Bowman has proven and shown in 56 years that he has the capacity to rehabilitate if he is not already rehabilitated. I know I submitted to the court dozens of work evaluations, letters of recognition and recommendation from Michigan Department of Corrections staff. And as someone who only does these types of cases, candidly, I don't see that. And so I agreed. We are asking the court to impose the maximum amount of years under the statute, 40 to 60, and we ask that you do that today. But I know that Mr. Bowen has prepared something in advance, and I'll turn it to him.
Thank you. Mr. Bowman.
Yes, Your Honor. I want to take full responsibility for the murder of Ronald Cron. November 22nd, 1968. I don't know if Mr. Ronald's family is there in court today, and I'm sorry for the pain.
Now, this case begs the question, what happens next in the world of criminal justice when laws change so drastically? Bowman's case is one of many that's been affected by the retroactive ruling, and it might not be the last. Will we see more violent criminals getting second chances? And what impact will this have on the victims' families who thought the justice system had already given them the closure they needed? The ramifications of this decision extend far beyond Bowman. It's a shift in how we handle the most serious of crimes. Who's truly benefiting here?
Of suffering that caused her family and loved ones. Mr. Crow was 19 years old, could have been married with children and grandchildren. His life was ahead of him, and I robbed him of that. And I'm sorry. I'm so sorry. I'd also like to apologize to Carter Calcaster for the fear pain I caused the residents of Calcaster County around the state. Everyone was afraid of their safety, and they took away from you, and then I took away from you. I'm sorry. I wish there was something I could do to ease your pain. I wish I was able to go back and make better choices. $56 ago. The only thing I could do is show kindness and show that I am a better person. Even today, there's not a day that goes by that I've had a thought about the suffering I've caused the family, and I'm so sorry. Thank you, Your Honor.
All right, thank you. I'm not going to say a lot about the details of the crime here. I don't think there's a lot that needs to be said about the heinous nature of the crime itself, and really just the senseless and needless loss of life here that occurred for really no reason at all. And I don't think that needs any additional commentary. I think what's important here today, number one, for me,
In the end, Daryl Bowman is sentenced to 40 to 60 years, a decision shaped by the shifting legal landscape of juvenile sentencing. While the victim's family will never fully heal from the pain he caused, the law has set a precedent for future cases like his. The changes to sentencing laws are causing rifts in the system. Some see them as a path to redemption, while others view them as an injustice to those who have suffered the most. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
to acknowledge all of the relatives that are here in the courtroom today. I think it's unfortunate that all of you are here today having to relive this because of a change in the law that now says that a sentence that you thought that you could all count on was wrong and shouldn't be imposed. And I thought it was particularly striking, Mr. Cronk, about your statement that you're here to carry through with the promise that you made to your parents about what you were going to do. Yet the state of Michigan isn't carrying through with its promise to you and to your family. And I think that's unfortunate. It's a change in the law that has really taken the discretion out of my hands as a judge in terms of what I can order. The statute speaks in terms of the court shall and the court must. And as a court of law, I am compelled to follow the law. I can't make it up, regardless of whether I agree with it personally or not. It's a change that determined that it's unconstitutional to sentence a juvenile to life without parole, that it's cruel and unusual. I think that's a change that doesn't take into account the fact that you all have been living a life of a sentence without parole. No one's ever going to let you out of the prison that you've all been in, regardless of any changes in the law. The way that perhaps Mr. Bowman may be someday released. It's a change that was decided by judges and legislators that never have to sit in the chair that I'm sitting in and look at all of you folks and listen to what you had to say and read what you have to say and see the true impact of this kind of a change in the law. That's something that they don't have to do. You make that decision in a different forum, and they don't have to look all of you in the eye the way that I do, and the way that the prosecutor had to do. But again, it's a change that's been made. It's a change that as a judge I'm bound to follow. And it's a change that doesn't leave me with much choice other than to impose the maximum possible sentence that I can impose under the restrictions that I'm now under. And that sentence is a sentence of 40 to 60 years. If I had the authority, Mr. Cronk, to impose additional time, believe me, I would do it. I don't have that authority. Again, the statute speaks in terms of the court must and the court shall. And so it is the sentence of the court, Mr. Bowman, that you serve 40 to 60 years in the Michigan Department of Corrections. You do have credit for 20,701 days served. To the extent that there are any fines or costs that remain that were imposed at the time of the original sentence, the court would preserve those. You do have the ability to seek an appeal of this sentence. The court's going to take a short recess. I do have another hearing at 2 o'clock, and I'm going to take a short break before I take that action.
Thank you, Ron.
All rise.